Court calls case of the People versus Marquita Simmons.
Before we even get into the details of this hearing, let's slow down and understand what kind of courtroom moment we're about to witness, because probation violation hearings can change someone's life in just a few minutes. This case involves Marquita Simmons, a defendant who originally received what many would consider a second chance. Her felony charge was reduced to a misdemeanor, and instead of going to jail immediately, she was placed on probation. In the legal system, probation is essentially the court saying, follow these conditions, stay out of trouble, and you can avoid jail. But probation isn't optional. It comes with strict requirements, things like reporting regularly, paying restitution, completing classes, community service, and maintaining contact with probation officers. Miss those obligations, and suddenly that second chance can turn into serious consequences. Now, according to the court records we're about to hear, Simmons allegedly failed to report, didn't complete required classes, skipped community service, and hasn't paid thousands of dollars in fines and restitution. Those are multiple violations stacking up over time, and judges often view repeated non-compliance as a sign that probation simply isn't working. But here's where the situation gets complicated. Her attorney is about to argue that Simmons is a single mother raising a 4-year-old autistic child while struggling with homelessness. That introduces a completely different layer to the story. Courts must balance accountability with real-world hardship.
She's under. Thank
you. Defender Natalie Pate for Ms. Simmons, who should be present via Zoom.
Looks like she is. Can you state your name, please?
Marquita Simmons, sir.
Your Honor, Ms. Simmons is before the court for a violation of probation hearing. She is at her 2-year max of probation term. She owes a balance of $3,775. She's made no payments towards her fines and costs and/or restitution. She's failed to report to probation as directed, failed to complete the theft class, failed to complete her 25 hours of community service, failed to complete or submit her fingerprints. She also held the bench warrant out of the 15th District Court. Given all of the violations in this case, probation is asking that she be remanded to serve 365 days in jail, that she complete the in-jail MRT program, with the court to consider an early release upon completion of that program, waive remaining terms, accepting the financial obligation, and discharge from probation.
Thank you, Your Honor. I did have the opportunity to discuss this with Ms. Simmons on a few occasions. We did discuss both the alleged violations as well as the recommendation. Ms. Simmons does acknowledge and admit that she has violated probation in those alleged ways. However, as to the recommendation, she represented to me that she is a single mother to a 4-year-old nonverbal autistic daughter. And very unfortunately, she did struggle with homelessness starting in December of last year. Last month, she was able to get into state housing in Flint.
This is the moment where the defense introduces what lawyers often call a mitigation argument. Instead of denying the violations, the attorney is explaining why they happened. And in criminal court, that distinction can be incredibly important. Judges generally expect honesty. When a defendant acknowledges mistakes but explains serious life circumstances like homelessness or caring for a disabled child, it can sometimes influence sentencing decisions. But there's another legal layer here. Probation is structured around accountability. Even when someone faces hardship, the court still expects some level of effort toward compliance. That's why the prosecutor emphasized earlier that Simmons made no payments and allegedly didn't complete required programs. From the court's perspective, the question becomes whether she tried and failed or simply stopped participating altogether. And this is where the tension starts building in the courtroom. You can hear the defense pleading for compassion, essentially asking the judge to discharge probation without jail time. That's a huge request. It would mean ending supervision despite all those violations.
We are respectfully requesting the court to consider discharging Ms. Simmons from probation without improvement, in ordering the restitution, of course, or continuing that order, but we are asking the court to consider not remanding her at this time. Ms. Simmons does acknowledge and take responsibility for the violations, but she is very concerned that if she was remanded, certainly to serve a year in jail, that her 4-year-old daughter would have, frankly, nowhere to go, and she has nowhere else that would care for her. and that we would respectfully request the court to not remand her or order any jail time, but to just simply discharge her from probation without improvement.
But she's done nothing.
And Your Honor, I would also like to state, this case started as a felony. I mean, the court is aware of that.
Yeah.
It was reduced down to a misdemeanor. And she's made no effort to get any of the things done. I do know that she had some communications with my office, indicating that she was never told, which they
Never told what?
that there was many attempts made by my office to get her back into compliance and or reach out to her. The only time that probation started to hear her, with any consistency was yesterday before court.
No, excuse me, Judge, may I speak, please?
Yes, go ahead.
I never even met Miss Ellen. After the court date and all the appearances and things like that, I tried to contact her to see what the stipulations of my probation was. She never contacted me.
Hold on. You're telling me you tried to contact my probation office and they didn't call you back?
This exchange right here is where the tone of the hearing shifts dramatically. Up until this point, the discussion was about circumstances and requests for leniency. But now, the judge is focusing on credibility, and credibility in court is everything. When a defendant claims that probation officers didn't return calls or provide information, judges often become skeptical very quickly. That's because probation departments typically keep detailed records of contact attempts. Listen to how the judge responds. He immediately challenges the claim and states he doesn't believe it for a minute. That kind of statement from the bench signals that the judge trusts the probation officer's account more than the defendant's explanation. And once a judge believes someone is shifting blame, it can seriously damage their chances of receiving mercy. Probation officers also rely heavily on documentation. Phone logs, appointment records, reporting forms. Those are all tracked. So when the officer later says she received only 3 monthly report forms over 2 years, that becomes powerful evidence. Let's break that down numerically. Probation required a monthly report. 2 years equals 24 reports. If only 3 were submitted, that means 21 were missing. In the legal world, that pattern doesn't look like occasional hardship. It looks like consistent non-compliance. So now the courtroom dynamic has shifted from sympathy to accountability.
Yes, sir. I
I do
emailed.
not believe that. I don't believe
sir.
that for a minute.
Yes, sir. I don't have no reason to lie on this lady or myself, sir. I did report where I was supposed to, and I contacted her, and I talked to the secretary lady. A lot of times she was always in court, and she said she'll give her the message to call me
Ms.
back.
Polera is only in court with me 2 days a week max. So that I know that's not true.
I don't have to lie to
If you
sir.
want me to go pull the phone logs, we can tell exactly when you may have called. What dates did you call?
It's been a long time. It's been over a year since I've called. That's been a long time. It's been over a year.
Sir, I can tell you, I received a total of 3 report forms from her in the 2 years.
Three report forms.
3, a total of 3 in the 2 years. I had phone conversations.
Well, just so the record's clear, that's a monthly reporting form.
Correct.
So if my math's correct, 2 years is 24 and only received 3.
Correct.
So we're about 21 short. Go ahead, Ms. Polera. I'm sorry.
I also spoke with her directly on March 20th. The violation of probation hearing was set then. When I spoke with her on that date, all I got was a lot of, I'm not going to do that and I can't do that. And I advised her that this court date.
I don't have
that
the
this court date
finances,
was
and I
set out
kept
to
telling
give her
you,
some time to get things completed, and she's done nothing.
I don't have the finances. If you're taking care of a 4-year-old autistic child, what finances do you have? I don't have the finances to pay for restitution. I've been said this in court a long time ago.
You had a felony that got reduced to a misdemeanor. You took the misdemeanor, got placed on probation for the longest you could. Give that time. You want to keep interrupting me? You go right ahead. And then you did nothing. And then you come before this court. You know, you don't even file the monthly form. That doesn't even require you to be there. You did that 3 times out of 24 times. You did you did nothing.
This is the critical turning point of the hearing. Judges rarely raise their voice or repeat phrases like this unless they've reached a clear conclusion about the case. What we're hearing here is frustration from the bench. From the judge's perspective, probation was already a major opportunity. Remember, a felony charge had been reduced to a misdemeanor. That's often viewed as the court giving someone a second chance to stay out of jail. But probation only works when the defendant actively participates. Filing monthly reports, completing classes, paying restitution, even small payments, those actions show the court that someone is trying to comply. When those things don't happen at all, judges often interpret it as ignoring the court's authority. Another key moment here is when the judge says the defendant tried to blame the probation officer. Courts take that very seriously. When someone shifts responsibility onto a court officer without evidence, judges may see it as refusing to accept responsibility. And acceptance of responsibility is one of the biggest factors that can influence sentencing decisions. This is why the judge repeatedly emphasizes the word nothing. He's not just talking about the missed payments or programs. He's pointing to a pattern of non-compliance over 2 years. At this point in the hearing, the outcome is starting to look inevitable.
And then you get here, and the problem, you then try to blame Miss Polera that she didn't call you back. First of all, in the years that I've worked with Miss Polera, that doesn't happen. You tried to call out and tried to blame the wrong person.
Right.
Anything else?
Nothing further.
Defendant is remanded to serve 365 days Washtenaw County Jail. I'm ordering that the defendant report to the Washtenaw County Jail by 6 p.m. today.
And there it is, the ruling. Judge Simpson orders Marquita Simmons to serve 365 days in jail. That's essentially a full year. But notice something important about the structure of this sentence. The judge orders her to complete an in-jail MRT program that stands for Moral Recognition Therapy. It's a rehabilitation program designed to address criminal thinking patterns and encourage behavioral change. Why does that matter? Because the judge also says he will consider early release if she successfully completes that program. That means the 1-year sentence may not necessarily result in a full year behind bars. Courts often structure sentences like this to combine punishment with rehabilitation. Another important detail is the judge ordering her to report to jail by 6 p.m. the same day. Failure to report would trigger a bench warrant without bond. That's the court making sure the order is taken seriously and executed immediately. But you can hear the reality of the situation in Simmons' response. She asks how she's supposed to get to jail by 6 p.m. without transportation. That moment shows how quickly life-altering decisions happen in courtrooms. In just a few minutes, someone can go from standing in front of the judge to facing a year in custody. Cases like this often raise difficult questions about responsibility, hardship, and how the justice system balances both.
Failure to report will result in a bench warrant. That bench warrant will issue without bond.
I don't have any way to
While
get to Washtenaw
Ma'am, you
County.
want to keep interrupting me?
I'm sorry, sir.
While in jail, the defendant is to complete the in-jail MRT program. I will consider early release upon completion. I will waive the remaining terms, accept the financial obligations, discharge the defendant from probation without improvement. And if you want to believe that I won't issue that warrant, ma'am, try me. Thank you.
Judge Simpson, how would I supposed to get down there at 6 p.m. with no transportation?
Court calls the case, People versus Jeremiah Stanley.
There's just a couple of under more attorney of an applicant. Really, for a few of you taking the record.
You have them or no?
He's there.
Can you hear me now?
Yes, I can hear you. He was being very.
Hello, sir.
I need a camera.
I've tried to turn it on. I don't know how. Things have
Well,
changed.
it's that you were upset about having to wait, so now we have to wait until you can turn your camera on.
Can you see me now?
amazing how that works. Miss,
Yeah, it just gave me an option, sir.
Your Honor, I did review, probation's recommendation regarding the violation. We do ask that you adopt the recommendation. Mr. Stanley and I, conversation about maybe some week, he says he's going to work on that as soon as possible. He is going to provide Ms. Blair with his, work authorization or work proof. And again, we ask that you adopt that recommendation today. And we did talk about the wait. He is very concerned because he's at work right now.
I'm sorry that my life happens to have emergencies. I'm on the bench every day. And
You're
if you
fine,
think for
sir.
him, I'm going to leave my daughter out on the side of a highway, not going to happen.
I'm sorry, sir. I totally understand it. I had a friend of myself. I had a friend of myself commit suicide this morning. I've had a very difficult morning, and I'm.
Ms. Valero, what did you want to tell the court?
Your Honor, I just wanted to provide to the court that Mr. Stanley is in violation of the terms that was ordered by the court. Probation would ask that the court give Mr. Stanley a chance to complete probation terms and is recommending that he serve 3 days in jail, credit for the 3 days that he served, that the balance of his $975 be paid by the application of his bond that he posted, that the court extend the prosecutor deferred for a period of 9 months, that he report to probation tomorrow at 11:30 a.m. in person, then as directed, that he become compliant with all previously ordered terms of this court within 30 days, with the final review hearing February 12, 2025 at 9 a.m.
Sir, anything you want to say before I impose sentence?
I agreed to give over the bond money to pay for the fines. That was the money I was saving up. I'm sorry that I failed to comply with the fingerprints and the outpatient therapy and everything else. I want to keep my job and not go to jail and lose it possibly.
Sentence of the court, 3 days Washington County Jail, credit for the 3 days that he served for the violations to date. He's to pay $975 or $975 balance today. I will apply the bond, which will account for 900 of that. The balance has to be paid today. I will extend his prosecutor deferred sentence for a period of 9 months. I'll order that the defendant is to report to probation on Thursday, May 9th at 11:30 a.m. in person and then report as directed. He is to become compliant with all previous ordered terms within 30 days. I will schedule a final review hearing on February 12th, 2025, 9 a.m.
Sir, is there any way that I can show up tomorrow to pay the remainder?
Fine. Pay it tomorrow.
All right, thank you, sir.
Are we done? Thank you.
Yes, sir.
This hearing ultimately shows how probation can become a crossroads between second chances and serious consequences. Marquita Simmons originally received a reduced charge and the opportunity to avoid jail through probation. But according to the court's findings, multiple conditions were not met over a 2-year period. Missed reporting requirements, unpaid restitution, incomplete programs, and failure to follow probation instructions. Judge Simpson ultimately determined that probation had failed. His ruling, 365 days in jail with the possibility of early release after completing the MRT rehabilitation program, reflects a common approach in courts across the country, combining punishment with structured rehabilitation opportunities. At the same time, Amwar Wack, the defense highlighted a difficult reality. Simmons claims she was raising a nonverbal autistic child while experiencing homelessness. Those circumstances add emotional weight to the case and raise broader questions about how personal hardship intersects with legal obligations. Courtrooms often operate at that intersection, where strict rules meet complicated human lives. And as viewers, it forces us to ask tough questions about justice, accountability, and compassion. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.